Take it away, sir.
Okay, well, thank you very much, Carolyn, and thank you, Tony, for the introduction, and thank you to everybody who is tuning in. This is a little bit of a different format, but it is a privilege for me to speak with you today about intellectual property basics, and in particular, we're going to be talking about patents and trade secret protection of your intellectual property. You should see on your screen a brief outline. Of course, there's the trade secrets and utility patents. We'll talk a little bit about offense versus defense. That's protecting your intellectual property versus avoiding other people's intellectual property. We'll look at overseas patent protection and how to protect your products and your services. I will conclude with a little bit about ownership of your invention, and then talented Jennifer Groff will pick up the topic of public resources for searching patents. As Tony mentioned, if you have questions, please type them into the chat box, and we will attempt to address as many as we can at the end of the webinar. So what is a trade secret? A trade secret is any commercially useful, confidential information that is subject to reasonable measures to keep it secret. Okay, it has to be commercially useful, keep it confidential, and take measures to keep it secret. Okay, so anything basically can be a trade secret, from your customer lists to your secret formula to how you make your product or service really hum. Perhaps the most famous trade secret is the formula for Coca-Cola. Well, how do we protect our trade secrets? You have to take affirmative steps to keep it secret. Perhaps one of the easiest ways is to encrypt your sensitive documents by requiring a password to open those documents. You may ask your employees to sign non-disclosure, non-use agreements, and we'll hear more about that in session 3. You can also use a visitor log. If somebody comes to your factory, you of course have a time in, time out entries, but also I've seen this used to great effect in a courtroom where a visitor signed the visitor log, and the opposing attorney had them read the fine print at the bottom of the page, and it said something like, by signing above, I hereby agree that I may encounter trade secrets and I promise not to use them or disclose them. And there's the visitor's signature. So that can be pretty powerful if you let people come and tour parts of your factory or sensitive areas, for example. Also, need to know disclosure. Let me give you an example of that. Let's say we all work for a cola company. We manufacture cola beverages, and I have the trade secret, and I'm going to pick a handful of our colleagues here from the audience, and I am going to ask each one to help me to manage that secret formula. To one colleague, I'm going to say, okay, your job is to make sure that there are 10 pounds of sugar whenever we make a batch of a cola beverage, but don't tell anybody, not even your colleagues, what your ingredient is or the amount. But for you, 10 pounds of sugar in every batch. For another colleague, I'll say, ma'am, your job is to make sure that there's 5 gallons of caramel color in every batch of our cola. Okay, don't tell anybody, not even your colleagues, the ingredient or the amount, and so on. And let's say Mr. Sugar goes off and works for a competitor. It's a free country, he's allowed to do that. I'm not saying that he would do this, and I'm not saying that our competitor would do this, but let's imagine the most evil motivations here. What harm can they do? All he can say is 10 pounds of sugar, that's all I know, because you have managed your trade secret, in this case, the secret formula. Trade secrets, ladies and gentlemen, really have teeth, both at the federal and the state level. A fairly new law gives you a federal civil cause of action. That's the Defend Trade Secret Act of 2016, and that really helps you to sue your competitors if they are using misappropriated trade secrets. Also, theft is criminal both on the federal level and on the South Carolina state level, and pretty much every state also has similar statutes, so it's pretty broadly applicable. I looked up the statute just before this talk to sort of see if I could put my finger on any differences between the civil cause of action and then the criminal acts that are prohibited. And the criminal acts are a little bit more about the theft of information. Your former colleague, you just fired your former colleague, and they're leaving the office and they're downloading all of your sensitive information onto a thumb drive. That's sort of the criminal act. Whereas the civil cause of action sounds a little bit more in misappropriation, which is to say use. When somebody starts using that information that they have obtained, perhaps they obtained it without committing any crimes, but now they're using it. And that's where the civil cause of action comes in. The tools that you can use include injunctions. An injunction is a court order in which the court says, you must not do this, or you must affirmatively do something else. You can seize the thumb drive, the computer equipment, wherever the trade secrets may be kept. You can receive actual damages and doubled damages. These are cash awards, and then also attorney's fees are available. So there are both sort of injunction type remedies and also cash damage type remedies available for trade secret misappropriation. Utility patents. Moving right along, a utility patent protects a useful, new, and non-obvious invention. When I say utility, I want you to think technology, okay? So is it a technical thing? We'll talk about other types of patents in a moment. But when we're talking about utility patents, we're talking about machines, processes, articles of manufacture, compositions of matter, and improvements thereof. I used to teach about patent law many years ago, and I would say improvements. And for example, they're still patenting the light bulb. People would say, no way, they're not patenting the light bulb anymore. That's 100-year-old technology. And then the curly Q light bulbs came out, and yes, sure enough, they are still patenting the light bulb because they are still innovating the light bulb. I suppose before those curly Q light bulbs came out, the improvements were a little bit more subtle, but they were still occurring. Another example of an improvement, well, there was the television, then the color television, and then the remote control color television. And you can see these improvements certainly, well, I'm telling you, they deserve and received patents. Now, there are exceptions to utility patents. Abstract ideas like freedom or insurance, natural phenomenon like lightning, but you can patent a practical application like the lightning rod. And of course also laws of nature. Newton could not have patented the law of gravity when he discovered it, for example. But you could patent a practical application like, let's say, the pile driver. You understand how gravity works. You raise a big heavy weight up in the air and then you drop it and pound something into the ground. That's a practical application of the law of nature, and the practical application, the technology, is patentable, but not the law of nature. When it comes to any kind of patent, really, the name of the game is the claim. Now, what is a claim? A patent claim is a numbered sentence that appears at the end of the patent document, and that numbered sentence, the claim, puts a fence around the protected intellectual property. Now, let us suppose, to give you an example, let us suppose that you've invented the ballpoint pen. Say, great, I should get a patent on this. The first thing after you search, and Jennifer is going to talk about searching, after you've searched and found out that yes, perhaps you have indeed invented the ballpoint pen, then our task is to write a claim that covers your technology. So here I have written a writing pen comprising a gripping portion comprising an ink reservoir in fluid communication with an ink depositing tip. That pretty much describes your ballpoint pen, doesn't it? Problem It also describes feather quill pens that have been around for a couple centuries. That means that this sentence would not be a valid patent claim because it also reads on, it also puts a fence around feather quill pens, and that's not allowed. You can't patent something that has been known for centuries. So back to the drawing board, how do we improve this patent claim? Let's add to the end of it further language, comprising a sphere for depositing ink from the ink reservoir to a writing surface. There's your ballpoint pen. That distinguishes your ballpoint pen from the feather quill pens, for example. And so now we are closer to what would be a valid patent claim that does not read on the prior art. The key, of course, to all of this is to work closely with your patent attorney, make sure he or she understands your technology, and so you can really accurately cover what has been invented and avoid what came before. Another aspect to all of this is that you'd want to claim different parts of your technology, from how to make it, how to use it, what kind of ink. I mean, there are going to be innovations in how do you put ink into a ballpoint pen so it flows when you write but doesn't leak all over the place, for example. And so you would look at not just a broad articulation, the broadest articulation perhaps of your technology, as I have written here, but also sort of ancillary parts of that technology to, put fences around all the aspects of that technology that you've invented. Design patents. Design patents protect new, original, and ornamental designs for an article of manufacture. Article of manufacture is anything made by human beings. And importantly, a design patent cannot protect the functional aspects of an article of manufacture, but only the ornamental aspects. A couple examples here: Nike shoes and graphical user interface icons. Each year, Nike redesigns the shoe. And let's imagine that they have not reinvented the shoe, although they do innovate the technology of shoes, but for our purposes here, they are simply redesigning the shoe so that they have a really nice design that everybody wants for the next season. Well, they would not want a discount retailer such as Walmart, not saying Walmart would do this, but a discount retailer might say, hey, Nike just came out with a new design. Can we make knockoffs that look pretty similar, sell them for 20 bucks in our discount retail store? Nike says, no, well, let's get some design patents on ornamental aspects of our new shoe design, and that can effectively protect our new design from knockoffs. A design patent lasts for 15 years from issuance. And then it expires. The design then passes into the public domain. Anybody can make knockoffs after the design patents expire. Plant patents. You can patent plants as well. And so long as those are distinct new varieties of plants that are asexually reproduced. Give you some examples relevant to South Carolina. If somebody comes up with a new variety of hemp plant, let's say it produces more CBD without producing the unlawful amounts of THC, well, that might be a plant variety that might be subject to a plant patent. There are exceptions here. Tuber propagated plants. What is a tuber propagated plant? Irish potatoes, Jerusalem artichokes, anything that is tuber propagated, sort of the underground little roots that shoot off and then swell up into new plants. Also, plants found in an uncultivated state. You can't just wander out into the woods and start picking flowers and trying to patent them. You have to asexually reproduce new and distinct varieties to seek patents on them. Okay, Should I protect an aspect of my technology with a utility patent or patents, design patents, plant patents, or should I protect that aspect with trade secrets? Answer, you'll probably use a variety of tools in your business. So for example, you might keep your customer lists as trade secrets because you can't patent that sort of information. Then other aspects you might consider patenting them. How to choose on a particular piece of technology, let's say. Well, let's ask, can a competitor reverse engineer your invention? So somebody goes out and buys your ballpoint pen, they pull off the cap, and your trade secret as far as the sphere in the tip, the little ballpoint tip, is immediately revealed. And so that kind of trade secret immediately gets revealed and it's no longer a trade secret just because somebody looking at your product or taking it apart a little bit can see what your technology is all about. That is that kind of technology recommends itself to patent protection. But if on the other hand, how do you make that beverage? Let's say it's a Coca-Cola brand beverage. And you're Coca-Cola, by the way, that is effectively protected with a trade secret because people can't reverse engineer what makes a Coca-Cola beverage taste like a Coca-Cola beverage. Next question, can a competitor independently invent your technology? Can somebody come along and just stumble upon something that tastes remarkably like a Coca-Cola beverage? Or can somebody else invent, let's say, the ink that you use in your ballpoint pen? If independent invention is possible, then you might consider patenting it. If independent invention, boy, how did they do that? It's really hard to figure out what exactly led you to your invention, to your technology. Then maybe keeping it as a trade secret is a better idea. Can infringement be detected and proven? Let's say you take a 12-step industrial process and you reduce it to a mere 5 steps inside your factory. This is wonderful, right? So you're going to practice the 5-step method, but are you going to patent it? Well, can you tell if your competitor is using the 12-step method or the 5-step method just by looking at their product, even taking it apart, even analyzing it as thoroughly as you can? If you cannot tell the difference between a 5-step product and a 12-step product, then maybe you might keep your amazing 5-step process to yourself. Keep it as a trade secret. If, on the other hand, you can pull off the lid of somebody else's pen and see if it's a ballpoint pen, well, then that suggests maybe you might consider a patent on that. Do you want to license or sell your invention? And here we're sort of thinking about somebody buying your technology so that they can use it, or let's say rent your technology. Renting is akin to licensing. Selling and buying obviously is where you transfer the entire ownership of your invention from yourself to someone else. Also, if you watch Shark Tank, do you need investment in your technology? Investors tend to favor patented technologies. And so if you think that you will need investment to bring your product to market, then you might consider getting some patent protection around that technology. Okay, we've been talking a little bit about how to protect your intellectual property with patents and trade secrets, but how do you avoid infringing other people's intellectual property that may be protected with patents or trade secrets? And so the question is, do you have freedom to operate? You're going to launch that remote control television on the market, but wait a second, does anybody have an active patent on the television itself that might block us from selling remote control televisions, even though the remote control aspect deserved and received a patent? So what do? You search for blocking patents. And if you find any, you might design around their technology. That, and of course, we'll learn more about that in session 4. If you do find that those some critical intellectual property, you might want to in-license it or purchase it. That is to say, rent it or buy it so that you can practice it. Also, when you're searching for blocking patents, you learn what you can patent. Where's the white space in the innovation out there, and what have other people disclosed? So that might be that might reveal areas where you can write some patent applications. Also, you want to avoid other people's trade secrets. You don't just want to win the lawsuit and be told, no, there's no trade secret misappropriation here. No, no, no. You want to avoid the lawsuit altogether. So you want to avoid the appearance of misappropriation. So when you bring on new employees, you want to check their prior non-compete and non-disclosure and employment agreements, because even employment agreements sometimes contain clauses that talk about non-competition, non-use, and non-disclosure. So these are things that you want to be aware of. And of course, you know, many companies adopt the policy, look, we're just not going to ask our employees to reveal or use trade secrets from previous employers, and they take steps that are fact specific to their situation to avoid even the appearance of that happening. Of course, a balance must be struck. People are free to work where they want. Just because you work with one company and learn some trade secrets there does not mean that you are forever beholden to that company and you can never work in your field ever again. But of course, the theft and misappropriation of trade secrets is not allowed. Okay, we'll talk very briefly about the patent application process. And how does that work? Well, you file an application with the United States Patent and Trademark Office. And indeed, that abbreviation USPTO is the main part of the domain name for the United States Patent and Trademark Office. That's uspto.gov. That's .golf Oscar Victor, and that would get you to the United States Patent and Trademark Office. And you apply there for a utility patent, and you submit to examination. That examination process, be forewarned, it takes years. I've gotten patents in as little as a year without taking any extra special steps. And then it's also taken as long as 5 years in some cases, and sometimes, unfortunately, even longer, depending on how crowded the art is and a number of other factors. Now, a patent is only good within its country. So a US patent is enforceable only in the United States and its territories. So if you want protection outside of the United States, you want to file patent applications in those other countries. One way to do that is to file a PCT application, we call it, or an international application, means the same thing. PCT stands for Patent Cooperation Treaty. And something like 152 countries have signed the Patent Cooperation Treaty. So you file one application, the PCT application, and it operates for a time as if you filed in all 152 countries. And you need to do that within 1 year after filing in the United States. Now, a patent will, a patent will last for 20 years from its filing date, and we'll see how that works. Here's the timeline, and this is one possible timeline for protecting your patentable invention. There are variations on this, but here's one that is commonly used, so let me go through it. The first thing we would do is we would file a provisional application. You see that over on the left-hand side of your screen. You file a provisional application in the United States. A provisional application is not examined and it expires after 1 year. But an advantage of the provisional application is that it also does not count against your 20-year term. Okay, so before the provisional expires at 12 months, we file a PCT application. And then 6 months after that, at 18 months from when you filed the provisional application, the PCT application publishes. Now, this is important because when the PCT application publishes, any trade secret that might be disclosed in your PCT application, if it was a trade secret before, it is now no longer, because the whole world can read your PCT application once it publishes. Then a year later, I mean, this is an important aspect of the Patent Cooperation Treaty scheme. A year after that, or 30 months from when you file your provisional application, you enter the national phase. Some countries it's 31 months, give you an extra month there, but basically 2.5 years after you file your provisional application, you've tested it, you've tested the market, you've done whatever you can do to decide whether and where you might enter the national phase. So you see that we've delayed some costs and some effort from, let's say, from the 12-month time period to the 30-month time frame. And then at that point, you'll enter a few countries. You pick a handful, US, Europe, Japan, and China. For example, in this example, you might add a few countries, Canada and Mexico, if you're North American centric, perhaps Brazil, Russia, India and China, the so-called BRIC countries, maybe add South Korea, and so you pick where you want to enter the national phase. And then your application is subjected to examination in each of those countries. Europe is a special case. They're sort of like a mini PCT operation, in that once you get your European patent allowed, then you validate in several countries, not all of them, it could be all of them, all countries in Europe who have signed the European Patent Convention. And then you have patents in those individual, or let's say a European patent that you can enforce in those individual countries. And you see that it can take as long as 5 years here in this timeline. There are ways to speed things up. I mean, you can skip this whole timeline if instead of filing a provisional, you just file a US non-provisional application way back at time 0 if you need a patent more quickly. The United States Patent and Trademark Office and the U.S. Congress have made it somewhat easier during the pandemic. In the CARES Act, and then, well, using authority granted to the United States Patent and Trademark Office by the CARES Act, the USPTO has instituted a few programs that will help you if one of two things. If, number one, you have a technology or even a trademark that is relevant to the pandemic, or if you have suffered some harm specifically traceable to the pandemic, you can seek extensions of time, waivers of petition fees, for example, and also prioritize examination of COVID-related inventions, and indeed also trademarks if that is relevant to you. So yeah, these are somewhat fact-specific, but takeaway here is if you've been harmed by the pandemic in your business before the Patent and Trademark Office, or if you have some technology or trademark that is relevant to easing the pandemic, then perhaps there is a program that can assist you in some way. How much does a patent cost? Broadly speaking, a patent costs about the cost of a new car. So do I get that new Corolla, or do I get a patent? That's approximately the comparison that we could use here. And so you want to budget something like $30,000 per patent per country over the 20-year term. That number goes up to $50,000 if we're talking about a language other than English, because you have to translate everything back and forth to and from English. You will spend about a third of that budget in preparing and filing the patent application. You'll spend a third prosecuting the patent application. Oh, and prosecuting here means the negotiation with the patent examiner over what is patentable, what is not patentable. There's a back and forth process there. And then you'll spend a third paying maintenance fees once the patent is issued. And these are all approximate. The United States Patent and Trademark Office will charge you on the order of about $5,000 in government fees if you pursue the PCT route to a U.S. Patent. If you file in the United States only, then that cost can come down to perhaps $1,000 or $1,500, depending on the size of your company and how diligent you are in responding to office actions and that sort of thing. Extension fees, increase the cost, obviously. The American Intellectual Property Law Association reports that an average attorney fee for preparing a complicated biotech or chemistry application is on the order of $11,000. That's your 1/3 spent for preparing that patent application. Okay, we're not in Kansas or South Carolina anymore. This is important to be aware of if you have any inkling of protecting your technology outside the United States. If you were to publish your invention on the front page of the Post and Courier or the state newspaper tomorrow, you would have 1 year within which to file for a utility patent in the United States. And if you included the design, well, you would have 6 months within which to apply for a design patent for that which you have published on the front page of the newspaper. However, very important, overseas, absolute novelty is required. That means your first disclosure, you can't offer it for sale, you cannot sell it, you cannot do anything of that sort. Any disclosure must be in a patent application. So you file your patent application, and then whatever is disclosed in that patent application, you can publish it or disclose it or use it or sell it or whatever you'd like to do with it. But and your ability to get a patent overseas is more or less still preserved, but your first disclosure must be in a patent application. In 2012, the United States joined the rest of the world to switch from a first to invent to a first to file system. It is now a race to the patent office. Well, what does that mean? Time was 2 inventors would file a patent application around the same time, and they would argue then, when it came to light that they both got a patent on the same thing or similar invention, well, who deserves the patent? We would dive into the laboratory notebooks to find out who invented it first. Now, under the current system, we just look at the filing dates and say, okay, who filed first? Great. But there's a caveat here. It's not just whoever stole the invention from the inventor and managed to file it first. It has to be an inventor who filed first. Okay, so if somebody merely steals the invention and files a patent application on it, no, they have to be a true inventor to deserve the patent under the current US system. How to protect your products and services. I mentioned this a moment ago, talking about the ballpoint pen. You claim the device, the whole device, you claim parts of the device, you claim methods of making, methods of use. Similarly, you can claim processes that you might use, especially technical processes. I mentioned here that business methods are patentable, but the asterisk indicates, business methods. The problem with business methods is that they bump up against the exceptions, abstract ideas in particular, and as such, they are disfavored. It is much better to try and cast your technology as technology, solving a technical problem with a technical solution, to avoid calling it a business method at all. I'll give you a very brief example, 2 brief examples. There was a case in which let's say we're going to show you a movie, but we're going to force you to watch advertisements in order to watch that movie for free. That was kind of a business method that was not patentable, even though it used computers and the internet and these, it used technology, but that was considered to be merely the patenting of an abstract idea. Another example that was patent eligible is, let's say you go to a travel website and you find a travel solution that you want to purchase. Well, back in the day, what would happen is people would then go they would leave the travel website and go to the specific vendor and book the flight or the cruise or the hotel or whatever. And the travel website wouldn't get any part of the action. So the technical solution here was to create a website within a website. It was the travel website, but now here's a website, web page within that looks like the travel vendor. And so that's how you can book your travel. The travel vendor, the airline carrier, the hotel, whoever, they get your booking, but then also the travel website also gets a piece of the action because they are able to create this web page within a website that looks and feels like the travel vendor's website. So that was a patent eligible business method, if you will. Don't call it a business method, call it a technical solution to a technical problem. Who owns my invention? Answer, initially, the inventor does, initially. Well, who is an inventor? An inventor is one who contributes to the conception of the claimed invention. So let's say we have a composition that you've invented. It's got ingredients A, B, and C. One inventor has proposed ingredients A and B, and another inventor says, well, let's add a little bit of ingredient C. That inventor, even if C is a minor ingredient, if the claim says A, B, and C, then that second person is also a co-inventor because they've contributed to the conception of that claimed invention. The inventor owns the patent absent a written agreement. We often call that an assignment. Okay, and why? Because the magic language down here at the bottom of the screen, I do hereby assign, transfers ownership in that invention, in that patent or patent application, even to future inventions. So you're hiring a new colleague, you might get them to assign especially if you're hiring them to invent, you get them to sign an employment agreement or assignment, whatever you want to call it, that says, I do hereby assign inventions that I may develop in the course of my employment. And so that gives the company ownership of the invention as soon as it is made. Okay, that's all I have. Thank you very much. We have some contact information, but I'm going to stop sharing now and turn it over to Jennifer, and she will talk about searching for prior patents.
Great. Thank you, Jeremy, and good afternoon, everyone. Hopefully you all can hear me okay. Great. Okay, so I'm going to be talking about patent searching next, and it's important to conduct a preliminary prior art patent search to see if similar inventions already exist, because as we've learned from Jeremy, patents are granted to inventions that are novel. So again, my name is Jennifer Groff, and as a Patent and Trademark Resource Center representative, I assist the public with patent-related questions. The PTRC program is run by the USPTO, the U.S. Patent and Trademark Office. And as you can see, Clemson and UNC Charlotte are both PTRC libraries. So if you want to do research in person post-COVID, you can visit either location that's closest to you. But please email me. My email address is here. I'm happy to help with any questions you might have. So today we're going to talk about patent searching strategies and publicly available databases, including the USPTO's PAT-FT, or Patents Full Text, which contains granted patents in the US, and AppFT for searching for published US patent applications. We're also going to talk about Esposnet, which contains patents from more than 100 worldwide patent authorities. I do want to mention briefly, though, there is a database called PubEast that's available at PTRC libraries that lets you search a number of different resources at once. However, you do have to search for that in person, but you can do a good preliminary patent search in the databases that I'll show you today. So Clemson Libraries has a patent searching guide that you can take a look at. The URL is here at the top. The Uspto and Esposnet databases are linked from this guide. I'd also recommend taking a look at and following the Uspto's 7-step strategy for conducting preliminary patent searches. It's a great outline. So step 1 is just to brainstorm terms that describe your invention. This is because it's important to search for synonyms of words that describe your invention, because you don't want to miss finding patents that use different terminology. So for example, if your company is developing a vaccine for COVID-19, you might search for different terms to describe the disease together with different terms to describe the vaccine. So for the disease, in addition to searching for COVID-19, you might want to search for SARS-CoV-2 and coronavirus in general. So now that you've brainstormed some search terms, you can go ahead and open the Uspto databases. Again, these are linked from Clemson's Patent Searching Library Guide, and you can also access these from the Uspto's website that Jeremy mentioned earlier, uspto.gov, under Find It Fast Patents. So today I'm just going to show you a quick search in patents full text. So when I go ahead and click on quick search, a number of search boxes do pop up. You can see there is a drop-down menu where you can see all the different fields you can search under, including patent titles, assignees, abstracts. If you leave the default all fields setting, you'll be searching in every part of a patent document. So I'm going to just start off over here. My example is searching for COVID-19 in the first search box and vaccine in the second search box as an all field search, because it's best to start broad and narrow your results later if needed. I do need to point out though that the database defaults to only looking from 1976 to the present for patents. So if you do need earlier coverage, you can select to search everything back to 1790. So when I ran that search, I did find 8 patents. They're always sorted by date with the most recent patents at the top. And you can see we're well over 10,800,000 patents in the database. To access the full text, you just click on the patent title. So if I go ahead and click on that first title, I come initially to an HTML page where I can see all the different patent sections. If you want a PDF to print or download, you do have to click images at the top of the screen. And that will open the patent document that you can print or download in the upper right-hand corner. So remember that you should go back and repeat your searches with the different synonym combinations you brainstormed earlier. As well. So, for example, coronavirus and vaccine, in addition to COVID-19 and vaccine. Just one caution, when I searched like this for coronavirus and vaccine in all fields, which is the default, I found more than 3,000 patents. So many of these just cited another patent or journal article that included the words coronavirus and vaccine, but the patents weren't really about coronavirus vaccines as a technology. So if you find too many patents to effectively review, one way you could think about narrowing your results would be to change your search field to require that your terms be found in the patent abstract. Patent applications are required to have succinct, clear, and descriptive abstracts. So if your search terms are found in the abstracts, the patents are very likely pretty relevant to you. So if I do this search in the patent abstracts, I find 24 patents that include the search terms coronavirus and vaccine in the abstracts. So I do want to spend a few minutes talking about patent classifications, which are areas of technology to which your patents belong. It's important to search by classifications as well as keywords. For example, in a patent, a pen might be called a writing instrument instead of pen, and it might not occur to you to search for that as a keyword. Also, keyword searching only works for patents from 1976 to present in the Uspto databases, but you can search for older patents back to 1790 by patent class. So the US and several patent authorities worldwide now use something called the Cooperative Patent Classification, or CPC system. And you can identify which CPC classes are relevant to your inventions by searching in a CPC database that's linked on that Clemson Libraries Library Guide, Patent Searching Library Guide that I showed before. And the USPTO's 7-step patent searching strategy also gives examples of searching by CPC class. So I've gone ahead and looked in the CPC database, and I found a patent class, C12N2770, 2034 that refers to the use of virus or viral components as a vaccine. And this is specific to coronaviruses. So I can, paste in or type in this CPC code, and I can change the field to current CPC classification. When I do this search, I find 188 granted patents with this CPC class. Some of these might be really relevant to you, yet different from the patents we found earlier through keyword searching. So definitely search for patents by both keywords and CPC class to get a complete picture of the prior art relating to your technology. So now I want to move on and show you just a few tips for searching Esposnet as well. This is a worldwide database with published patent applications and granted patents. And you can see the URL here for Esposnet. Rather than just typing, your keywords in the box, I'd recommend starting by clicking the advanced search option. It'll turn green and pop up some additional search boxes in the left frame. You'll see a lot of boxes here, but we're just going to focus today on the boxes that are connected using the operator and, like we did, with our earlier searches in the Uspto database. So I can go ahead and type coronavirus and vaccine in my search boxes. And if I click on the field, the drop-down menu at the top, I can change the search field to only look for patents where the search terms appear in either the title, abstract, or claim sections of a patent. These are all very important sections of a patent document. So when I do this, I find 890 worldwide patent documents. There are several ways you can narrow your results further. So I'll give you some ideas. You can always click the add field button, this plus field, to add extra search boxes. So if you have a specific company or inventor you're interested in searching for, you can change the search field to inventors or applicants. And so I've gone ahead and entered Pfizer as an inventor or applicant, and I have found 28 patents on coronavirus vaccines where Pfizer is an inventor or applicant. And these may be granted patents or patent applications in Esposnet. Instead of narrowing by company, I can also just narrow my results by adding additional search terms as well. So if I decide that I'm only interested in coronavirus vaccines that are live attenuated, for example, I can just add the phrase live attenuated to my search and the title, abstracts, or claims. And in this case, I find 85 results that I can go through. If you want to look at a patent document, you can just go ahead and click on the patent titles. So this third patent, for example, it's from China. It's specific to COVID-19. It's bat-derived coronavirus vaccine. I can click on the title and more information will pop up over here on the right frame. In this case, the original patent document is not in English, but the title and abstract are. If you want to download an entire patent document, you can click the 3 dots in the upper right corner and download the patent as a PDF. There is also a drop-down menu in the middle that allows you to view specific parts of a patent document. So here I've selected to just look at the claims. These have been machine translated into English as well. So in Esposnet, you can go over here and just select the patents that are interesting to you using a little checkbox. And then I can click, there's 3 dots in the middle, that's a menu. I can download an Excel file with information about every patent I've selected, or see a PDF document with the first pages of every patent document. You don't have to view the documents one at a time. Any Excel file you download will have key data about each patent, such as the titles, inventors, priority dates, and CPC classes. And the publication numbers are hyperlinked, so you can go back to the records in Esposnet easily from your Excel file. Just one final note, like in the Uspto databases, you can search Esposnet by patent class. So here I've changed the search field to CPC, and I've entered that CPC class we identified earlier for coronavirus vaccines. And I'm searching that together with the word COVID and the titles, abstracts, and claims sections of the patent. I find 13 results, including that bat-derived coronavirus vaccine patent application that we found earlier. So that's really all I want to say about basic patent searching. I just want to end with a couple of URLs that might be most helpful to you. Final note though, because inventions are publicly disclosed, like Jeremy mentioned, in non-patent literature as well as in patents, you may choose to look at things like journal articles, conference proceedings for prior art as well. I can definitely help you with that if you'd like to reach out to me with any patent related searching questions. Again, my name is Jennifer, and here's my email address. And thank you very much for your time today. I'm going to go ahead and stop sharing.
That was great. Thank you, everyone. Can everyone hear me?
Yes, Tony. Before you get started, I have a couple of people that I'm still trying to get their full names in the registration to confirm registration and attendance. I have a Teresa logged on, but I don't know your last name, Teresa. And I have a Shonda Williams logged on that I do not have that name on our registration list. So if you could type those names in the chat box. And then, Tony, if you don't mind, there were a couple of questions that were sent to me privately. So may I pose those questions first?
Okay, sure. Go ahead, Carol.
So one of those is to Jeremy, and it is, if a clothing pattern for a facial covering like a mask is freely available for tutorials online, is that available to trademark? Can a similar vendor say you can't use the design, yet the same design is available for free on the internet as a utilitarian clothing item?
That is a very interesting question. Let me just make sure I'm not muted. Okay, I'm not muted. I would suspect that somebody else posting something on the internet is not available to you, to me, to claim intellectual property rights in it. If you then were to take, let's say, your own mask and you were to put, let's say, your trademark on the mask, you might be able to protect that trademark that appears on the mask. Caution there is, does the trademark that you're putting on there, is it merely ornamentation, or is it actually a trademark that you're putting on the mask? And so those are concerns. But what got me in this hypothetical was that the design of the mask came from somewhere else. And then we want to claim trademark rights in that mask. Without more, that doesn't sound like you can do that.
Here is another question.
Carolyn,
oh,
one thing.
please.
I would just remind the person who posed that question that to certainly register for session 2, which will cover trademark and copyright protection, and Doug Lineberry will be the presenter there. So for those folks who want more information about trademarks and copyrights, please register for session 2.
Oh, thank you, Tony. Here's another one that came to me privately. How does ownership work when the invention was done while executing a federal grant proposal?
Well, I would need a couple hours to talk about the Bayh-Dole Act. But long story short, the inventor owns the invention absent a written agreement. Even if it's federal grant money, the inventor tends to own that invention unless and until there is a signed assignment. Now, the government might have march-in rights, and there are other things to talk about, but recent case involving Stanford v. Roche, I think is the name of the case. The Supreme Court said the inventor owns the invention absent a written agreement.
That's very good, Jeremy. That's about right. Having been in academic tech transfer for years, that's always been a big issue, but clearly the university generally owns any invention which comes out of a federal, or frankly, any invention that investigator who is a employee of the university invents something, it would belong to the university. Generally, they have assignments when they come on board, so that would take care of that.
Yes.
And Tony, that's all of the private questions that I received. You should be able to see the ones that were posed to everyone.
Okay, so I have a couple questions here. And I guess this would be for Jeremy as well. Here's, if I understand this correctly, someone asked a question about, everyone probably is familiar with Open Office, which is a piece of software which is similar to Microsoft Office. and it's an open source software. And the question was, this person was told that OpenOffice was allowed to include Microsoft Office features that are in the last release. Is that true? If I understand the question correctly.
I would dive into the fine print in the Microsoft Office click wrap license to confirm what uses are available for those Microsoft Office features. That's where that answer would be.
Okay. One question that this wasn't a question that came up, but I thought that during your talk, Jeremy, that you might want to comment on, and you did a great job in talking about inventorship and patents. I was wondering if you might want to explain what undivided interest is. I think that sometimes that becomes a very complicated topic for most inventors, if you know what I'm talking about, right?
Yes, if two people own a patent application, or let's say a patent, two people own a patent, they both have an undivided interest in that patent, whether it's 50-50. I don't know that that's relevant, because so two inventors, two co-owners, each co-owner can go off and exploit that patent, sell the technology, make $1 million. They do not need to ask the other co-owner for permission, nor do they need to give the other co-owner a dime. Okay, so they don't need to share profits. There's no accounting. There's no permission needed. So if you are a partial owner of a patent, you can go and fully exploit that patented technology, provided you have freedom to operate, looking beyond the patent, but you do not need permission, nor do you owe an accounting to other co-owners.
Unless, of course, there's some sort of an agreement, as you mentioned earlier, between the inventors.
Exactly.
That may detail who would get the goodies in the case of a commercialization of that particular patent.
And Tony, if I may, let me emphasize something that you pointed out earlier. Usually when a person sets foot in a university, they immediately are asked to sign an assignment. Okay, so what I said about the question about when you're inventing something on a federal grant, that is, my comments were in the absence of a signed agreement, but usually the usual case is that the university will say, please sign this assignment that says, I do hereby assign anything I invent in the future during the course of my collaboration with the university. So that is exactly right on.
And oftentimes that is the subject of some controversy. But as far as I know, there's, with the exception of a handful of universities in this country, it's been upheld that the inventor has to assign his or her rights to the university, to anything that comes out, irrespective of whether it was invented under a grant, under a federal grant or not. Let's see here. Someone asked the question, can you give another example of a business service or process that could be eligible for patenting?
No.
Okay.
I was trying to think how to, I saw that question in the chat, and so I want to say two things. First, there's sort of the process. We look at the claimed invention, and we ask ourselves, is the claim directed to an abstract idea? Then we say, if it is there something more that significantly adds to the claimed invention, so that it is not merely directed to an abstract idea with a little bit of and apply the abstract idea kind of language in there. And so I started racking my brain. Those additional steps cannot be merely routine or conventional additional steps that don't add significantly more to the abstract idea. So I started trying to come up with a business method that we could talk about. Let's say you've invented the drive-through. Okay, restaurants back in the day didn't have drive-throughs. You couldn't drive up to a window and get your food and drive away. So somebody had to invent the drive-through, right? And so could they have patented the drive-through concept? Answer, I just don't think that could have been seen as a patentable invention because of it would have been seen as merely a method for organizing human activity. It wouldn't really have sounded as a technological solution to a technical problem. So what do? If you really want to use a utility patent tool in that context, you might try and patent the technology of the window that you use in your restaurant, because I'm sure there were aspects of the window that were new and useful and not obvious, let's say. Perhaps the technology by which you can communicate with the car that's parked or driving up behind the restaurant, speak into the clown's head and tell them your order. That communication technology would have been patentable. So what I would be looking for is sort of the technological innovations surrounding that method of doing business to look for utility patent eligible aspects of the intellectual property.
Okay. Here's one other question, and getting back to what's patentable. The individual asks, can I patent an application? And I'm assuming this person means a software application. That is an application that is a new idea, which is not already in the App Store.
So far you're meeting at least one of the criteria for patentability, and that is that it is novel. It's never been done before. It hasn't been done before. I mean, I'm going to extrapolate a little bit from that comment. It also must be not obvious. Sometimes you'll hear people say, I heard this a lot, let's say a few years ago, I want to be the Uber for fill in the blank. I want to be the Uber for this. I want to be the Uber for that. Or I want to be the Airbnb for this new application. And the question that arises there, well, if you're just imitating Uber, but in a new way, but maybe it's novel, but would it be obvious over what Uber has already done, or Airbnb, what they have already done? That might be obvious. So that's a hurdle to overcome. Another hurdle to overcome is it useful? Is it a technological solution for solving a technical problem? And I gave two examples. One where we were merely making you watch advertisements while you watch the movie. That is using technology, but that was considered to be not patent eligible, versus the website within a web page in the travel website context. That was considered to be patent eligible. But boy, they sure did sweat a lot of bullets trying to having to fight over whether that was patent eligible. So you really want to look for a technological solution to a technical problem. And if your app does that, then potentially it could be patent eligible and patentable. And the difference there, patentable, I mean that it doesn't read on what other people have done. In this case, it's not, it's novel by your comment, and then it's also not obvious, and then it's patent eligible, and that it's technical.
Isn't another hurdle here in this particular situation to overcome is whether or not the code that is behind that application is actually in the public domain already? One of the problems that I've always encountered with regard to software applications or apps, because there's so many of them around, is, and many of them use algorithms and pieces of code which are already out there in the public domain. And I've always thought that would not be a patentable element, because the code that actually describes what the application does is already in the public domain.
That is going to be a very interesting question. So if you take known elements and you combine them in a new way, it might be novel, but also might be obvious and therefore not patentable. So I'll give you an example. We know pepper, we know salt, and your invention is to combine pepper and salt into a single shaker according to your preferred ratio of pepper to salt. Both ingredients are being used in the same way for their known purpose as spices, and so that probably would be obvious and not patentable. But if we are combining, let's say, salt and glue, and we're making, I don't know, some kind of toy out of it. Okay, something more useful than a toy. We're making whiteout. Okay, it's who knew that you add a little salt to glue and you just squirt it on your typewritten page and then you peel it off and it completely removes the ink. Who knew? These are both known elements, the salt and the glue, but who knew that you could use them as a whiteout material? So known elements for a new use, a non-obvious use, might be patentable. So it depends. So now let's go into using elements of software that are known. It depends on whether we're using them in a combination that is known or not. My ability to create a metaphor or analogy here is falling apart. But you see what I mean? Are we using these software elements in the same way that they're known to be used? That might not be, it might be obvious. If we're using them, wow, who knew, in this completely new and non-obvious way, then that might be patentable.
Okay. There's one other question, maybe best left for the next session, but I want to make sure I try to abide by the request for the question, and that is, let's see here. Would educational trainings, courses, and videos fall under copyright? And if so, will that be covered in the series? And actually, yes, it will be covered in the next session too, with Doug Lineberry. So either you can give it a few tidbits of information, Jeremy, or we'll just hold off. What do you, go ahead if you feel like comfortable in doing that.
Copyright.
Yeah, would a course or video fall under a copyright?
It sounds like it would be copyright protected material.
Okay. And I would ask that person, if you want to join in session 2, be sure to ask that question to Doug Lineberry next week. Okay. This is a question. And do we have attorneys on the video call that would be willing to help with patents or trademarks? And I'll answer that question. Absolutely. I'm sure that Jeremy and Doug would love to provide some assistance with your particular project. And you have their contact information in case you would like to contact them. Okay, I think that's it. Any other questions?
Tony, I have one last question that was sent to me privately, and it's kind of lengthy, so bear with me.
Okay.
I'm going to read it verbatim. This is similar to the question just asked, and I believe that's in reference to the can I patent an application? When applying for a residency at a university, part of the verbiage says, depending on the type of work proposed, agreements will clearly delineate specifics relative to ownership, rights, and intellectual property. For those of us that have never dealt with an open-ended question like this, how should we move forward, especially this is verbiage prior to receiving funding for the residency or other similar opportunities for which an intellectual property be produced? Where can where can research be done to justify a price for the opportunity for the residency? What resources are available to read up on this subject? Thank you.
That is a very interesting fact pattern. I don't know that I could give anything useful or helpful in just a brief comment here. Talk to your friendly neighborhood intellectual property attorney to take a look at it. Of some help is the university's intellectual property policy, which is often available online, and that may give you some insight there as well. As Tony and I were discussing, it is very usual for colleagues joining a university to sign an assignment saying anything that I invent, I do hereby assign. A wrinkle to that is that if you are being hired to invent something, there is a small exception. I keep hammering away. There needs to be a written assignment. If you are hired to invent something, that may also cause you to have to assign, or the law will consider you to have assigned your invention to your employer who hired you to invent in the first place. It is, long story short, it's very usual to sign documents. If you have questions about those documents, see your friendly neighborhood patent or intellectual property attorney. And as Tony mentioned, Doug Lineberry is a very talented intellectual property attorney, and I too have been mistaken for an intellectual property attorney as well. So we're happy to help.
Well, thank you very much, everyone. I think that's going to wrap it up. Unless there's other questions, please look at the slide on the screen here now. That we need to have you to fill out a post-event survey, which Carolyn will be sending out to everyone. And with that completed, then you will have access to the presentation slides that were presented today. So thank you everyone for joining, and we look forward to seeing you next week at session number 2, where we'll talk about trademark and copyright protection. And the presenter, as I said before, will be Doug Lineberry from Burr Foreman up in Greenville. So thank you very much.